Hello everyone. Today we are going to discuss the law subject that is labor law, and under this labor law we are going to discuss the act which is Workman Compensation Act 1923, and in this we are going to discuss the aims and objective and scope of the Workman Compensation Act 1923, right? And so let us start with the act with its aims, objective, and scope. The Workman Compensation Act 1923 is an enactment that was issued by the central government, right, and was implemented by various state governments, which gives social security to workers. So the purpose of it is to give social security to workers. Workman Compensation Act 1923, right? The security is offered by the law for the people who work. So it is basically those who are engaged. No, it is basically for the workers. That's why it is Workman Compensation Act 1923. The act was formed after it was noted that the laborers were getting more exposed to danger with the use of advanced and sophisticated machinery, right? So there was more risk and danger in the industry. So in order to safeguard their rights, it was made. This act was enacted. The common law had it that the employer would only take up the compensation responsibility if it is found that the industrial accident was a result of his negligence, right? So if there was negligence, then only he was liable. So in India, the issue of compensating workmen after fatal and major accidents hit the road in 1884. It was then in 1885 that the factory and mining inspectors realized that the fatal accident 1885 1885 was not enough to attend to the intended purposes, right? The state offered a hearing the state offered a hearing ear the state offered a hearing ear when members of the legislative assembly, employers, representative workers, and experts in medicine and insurance formed a committee that gave a report that led to the enacting of the Workmen's Compensation Act in 1923, right? The passing of the act put a stop and offered a relief for workers who would have gone through court processes that are often expensive, and an effort to seek compensation whenever they acquired an injury during employment, right? Let's move further. Aspect of the Workman Compensation Act. So what are the aspects? The act has its basis on two aspects. One is theory of least cost, right? The production cost shall have the cost of blood and workmen included, right? So the production cost shall include cost of blood and workmen included. So let us see. For an industry to run, an employer uses capital, skills in business, and the labor of workers who are paid for the labor. The management has to put aside finances for the possibility of the expenses needed to repair the machines when they break down, right? If that care and attention can be given to machines, human beings working in the same environment need also receive care and attention for the risk they undertake when working in that industry. Social Security offers to ensure compensation is paid to a disabled or injured person only if the accident rose in the middle of the employment. The compensation paid to a workman by an employer when an accident occurs is a relief and social security measure provided by the Act. A workman is now able to get compensation regardless of his negligence. Right? The Act also puts in place the amount that is to be paid according to the intensity of the injury. This makes an employer aware of the amount of compensation he is liable to pay in case of an accident. Right? The Act is recognized all over India and applies to all workmen and casual workers in factories, plantations, mines, transport establishments, railway, ships, cruises, construction work, and any other potential dangerous occupations made mention in Schedule 2 of this Act. This Act is not applicable to people in the armed forces. So it is not applicable to people in the armed forces, right? Let's move further. Objective of Workmen Compensation Act. Before this, I would like to mention important thing that I have, as this is a pandemic period going on, COVID is going on. So all the videos which have been made by me the content of all those videos has been taken from the Google, on the respective blogs available on the Google, right? So I've taken all the materials content from there, from Google, from the respective blogs, right? So I repeat, I have no copyright over the content. I repeat, I have no copyright over the content. Okay, let's move further. The Workman Compensation Act of 1923 was formed majorly to give compensation to workmen in the event of an accident. The act has it that employers should have duties and obligations that include the welfare of workers after an injury resulting from employment in the same way they have reserved the right to make profits. The Act aims to see workmen have a sustainable life after an employment related accidents. Right? Royal Commission on Labour made note of the following. So these are the notes, right? These are the following things which was observed by the Royal Commission. The Act also goes further to ensure the prevention of accidents by giving workmen a relief from anxiety and renders the industry more friendly and desirable. It has become a necessity for workmen to be protected due to the increasing complexity of the industry through the increased use of sophisticated machinery that poses a potential danger to workers and also the possibility of poverty after injury. Right? The Act tried as much as possible to curb the chances of disputes, which has led to events which are arbitrary. However, the general outcome is satisfactory since the merits are more than the demerits when it comes to the welfare of workmen. So let us see what is the scope of the Act. The Act is applicable only to those workmen working in industries as specified in the Act. So whatever industries which have been specified in the Act, only it is going to be applicable only on those industries, right? So only on those it is going to be applicable only to those workmen working in the industries as specified in the Act, right? Let's move further. The Act affords protection to a workman from losses or injury caused by accident arising out of land in the course of employment, subject to certain exceptions as laid down in the Act. Employer's liability for compensation. So let us see what are the liability for compensations. To make the employer pay compensation, the death or injury suffered by the workman must be consequence of an accident arising out of and in the course of his employment is dependent upon the following four conditions. So these are the four conditions. The causal connection between the injury and the accident, that is personal injury caused to workmen while on work, the injury and accident caused during the course of employment, the probability tenable to reasons that the work contributed to the causing of personal injury. The applicant, and the condition number 4, the applicant proves that it was the work and the resulting strain which contributed to or aggravated the injury, right? So let us see the applicability of the Act, right? The Act is applicable throughout India except the state of Jammu and Kashmir. As we know, the special status of Jammu and Kashmir has been abrogated, so it is now applicable to whole of India. The Act does not apply to those areas which are covered by Employees State Insurance Act 1948, right? So it is State Insurance Act also, right? I mean, it is not. It says the Act does not apply. It is not applicable to Employees State Insurance Act 1948, right? Those area which are covered by the Employees State Insurance Act, right? So let us have a look at the salient features of the Act, which are as follows. And extent and application. As we have discussed earlier, the Act extends to the whole of India. It is also applicable to the workmen recruited by companies, establishments registered in India and sent for work abroad, right? It applies to all railway servants not permanently employed in any administrative, district or subdivisional office of a railway and not employed in any capacity as is specified in Schedule 2 to the Act, right? Persons employed in any such capacity as is specified in Schedule 2 to the Act. Schedule 2 includes persons employed in factories, mines, plantation, machinery propelled vehicles, construction works, and certain other hazardous occupations. In all, there are 48 employments listed in the schedules. So there are 48 employments which are listed in the schedules where this act applies, right? Persons employed in employments added to Schedule 2 by the state government in exercise of the powers conferred on them under Section 2, Clause 3 of the Act. In this section, a statement indicating the additions made so far by different state governments is enclosed as Annexure 1, right? Now, so there is no wage limit for coverage under the Act. So there is no wage limit for coverage under the Act. All employees employed in the scheduled employment, including the railway servants mentioned at A above, at the point A above, are therefore covered under the Act, right? Let us see contingencies in which compensation is payable. So what are the contingencies and situations at which what are the conditions, what are the situations where compensation is payable? So let us have a look at those situations, contingencies. Compensation is payable in case of temporary, permanent disablement or death as a result of an employment injury. The contracting of any disease listed in Schedule 3 to the Act is deemed to be an injury by accident, right? And after that we have occupational disease. If a workman employed in the employment specified in Schedule 3 of the Act contracts any occupational disease peculiar to that employment, he becomes eligible for payment of compensation under the Act, right? The occupational disease should be contracted while in the service of an employer in the specified employment. The Schedule 3 divides the occupational diseases in 3 parts, namely Part A, Part B, and Part C. So for diseases specified in Part A, there is no qualifying period of employment. In case of diseases specified in Part B, a person should have been employed in the specified employment for a continuous period of not less than 6 months before the disease is contracted. For the disease specified in Part C, the qualifying period is specified by the central government. The qualifying period specified for the disease figuring in Part C of the schedule is as given below. Right? It is pneumoconiosis. It is pneumoconiosis, that is for 7 years. Pagasosis. It is pagasosis, 3 years. Bisonosis. It is bisonosis. It is bisonosis. It is bisonosis, 7 years, right? So these are the qualifying period for the respective diseases, right? Okay, let's move further. It basically says if a person has worked for this much of period, right, and during this a person gets this disease, then he'll be eligible for that, right? So it says for the diseases specified in Part C, the qualifying period is specified by the central government, right? So this is the qualifying period specified for the disease figuring in Part C of the schedule, right, which is as I said, right? So these are specified these are the these are the qualifying period, which is these are the qualifying period which is specified by the central government, right? That is pneumoconiosis for 7 years, pagasosis for 3 years, biasnesis 7 years, right? Let's move further. So these are the important things which we have to consider, which we have to take into consideration, right? Which we have to keep in mind, right? So these are the important notes. Where the monthly wages of a workman exceed 2,000 rupees, his monthly wages for the purpose of A and B above shall be deemed to be 2,000 rupees, right? So as for the two diseases above A and B, it will be 2,000 rupees. The minimum rate of compensation for permanent disablement and death specified in the Act is rupees 60,000 and 50,000 respectively, right? For the permanent disablement and death, that is 60,000 and 50,000 respectively. The maximum amount of compensation works out to about rupees 2,74,248 for permanent disablement and rupees 2,28,540 for death, right? So let us have how the administration is done, right, under this Workman Compensation Act. Okay, it says the work does not provide for appointment of inspectors. However, under Section 32 of the Act, the state government, union territory administrations have to frame rules to carry out the purpose of the Act. The rule-making power under the Act was originally vested in the central government, and in exercise of these powers, the Workmen Compensation Rules 1924 were framed. Some of the state governments have subsequently framed their own rules under the Act, right? In this connection, a system showing the names of state union territories which have so far framed necessary rules under the Act is attached as Annexure 2. The remaining states' UTs are being reminded to expedite the framing of the rules under the Act, right? So let us see how the settlement of the claims under the Act is done, right? The claim of the compensation broadly falls in 3 categories, namely uncontested cases of disablement, disputed cases of disablement, fatal cases, right? So let us have a look at the procedures. The procedure for settlement of 3 types of cases are as given below. First is uncontested cases. So these are the way here, with the help of these 3 categories, we are going to understand how the settlement of claims under the Act is done, right? So let us have a look at the uncontested cases. After a workman has given notice of the accident, the employer is expected to arrange for medical examination of the workman, right? So it is the responsibility of the employer to arrange for the medical examination of the workman. It must be free of charge. There should be no charge. The medical examination will indicate the nature of the disablement, right? So it will indicate the nature of disablement, right? If the disablement is of temporary nature, the employer will pay compensation as half monthly payments direct to the workman, right? So in case of temporary nature, if the disablement is of temporary nature, right? So after some time it will be cured, it will be healed. So the employer is supposed to pay half monthly payments directly to the workman. If the disablement is of permanent nature, compensation will be paid in lump sum by the employer to the workman if he is a male over 18 years of age. In the case of women, and minors, the employer will deposit the amount of compensation with the commissioner for disbursement. If the workman is above 18 years of age, so it will be directly given to him, right? It will paid to the workman, right? And in case if the workman is woman or minor, the employer will deposit that amount of compensation with the commissioner, right, for disbursement. Where a workman has agreed to accept and has taken a smaller sum than the amount fixed by the Act, his right to proceed proceedings for the balance are protected, right? An agreement with the workman for a lump sum payment must be registered with the commissioner by the employer. It says any agreement with the workman for a lump sum payment must be registered with the commissioner by the employer, right? If there is any agreement, so that has to be intimated to the commissioner. So commissioner is supposed to be informed of any agreement between the workman and the employee, right? Let's move further. In case of contracting of disease, the accident is deemed to have occurred on the first of the day during which the workman was continuously absent in consequence of the disablement caused by the disease, right? So the accident is deemed to have occurred on first day of on the first of the day during which the workman was continuously absent, right from the first day. Fatal cases, the amount of compensation due has to be deposited by the employer with the commissioner for workman's compensation. The act specifically provided that no compensation made directly by the employer shall be deemed to be a payment of compensation, right? The commissioner shall distribute the lump sum amount of compensation to the dependents in such proportion as he may decide, right? And the point number 3, that is, if the employer does not deposit the compensation, the dependent or the dependents have to make an application to the commissioner in Form G prescribed under the Workman Compensation Rules for the issue of an order to deposit compensation, right? And now let us have a look at this extension of provision of the Workman Compensation Act to hazardous employment in agriculture. So it is also applicable in case of hazardous employment in agriculture. So it is extended there also. Let us see how does it work. The Workman Compensation Act 1923 already applies to workers employed in farming by tractors or other contrivances. Contrivances means equipment, heavy equipment, driven by steam or other mechanical power or electricity, etc. The state government of Andhra Pradesh, etc., were advised in March 1976 to consider addition of the following employments to Schedule 2 of the Act in accordance with the provision of subsection 3 of Section 2 of the Act, right? So following additions were asked to be considered by state government in order to be included in this Schedule 2 of the Act, right? So and these are the following additions. So let us have a look at the additions. Employed in cleaning of jungles or reclaiming land or ponds in which anyone it says employed in cleaning of jungles or reclaiming land or ponds in which on any one day of the proceeding 12 months more than 25 persons have been employed, right? So if more than 25 persons have been employed, right? Okay, so it says employed in cleaning of the, so if there is any cleaning of jungles, right, where people have been employed, right, or reclaiming of land or ponds in which on any one day of proceeding, so any one day of proceeding 12 months, right? So there should be a period of 12 months and there should be at least 25 persons working there. So there should be at least 25 persons working in cleaning of jungles, right? Employed in cultivation of land or rearing and maintenance of livestock, of forest operations, or fishing, in which only one in which on any one day of the preceding 12 months more than 25 persons have been employed, right? So it says it is not proceeding, it is preceding 12 months. Let me make it clear. It is not preceding 12 months. It means there should be a period of at least 12 months where people have been working, right? And those people, the group of people who are working there should be at least 25, minimum 25 persons should be employed there, right? So it is not proceeding, it is, let me correct, it is preceding 12 months, right? Not preceding 12 months. And it's in which on any one day of the preceding 12 months, right? So there should be a period of 12 months between which 25 persons have been employed there, right? And the employment is such: cleaning of jungles. So these are the categories: employed in cultivation of land or rearing and maintenance of livestock, right? Okay, Employed otherwise than in clerical capacity. Clerical capacity, it means that you are not doing clerical work, right? The administrative and just keeping the files and all. It is not that. In installation maintenance, right, it is otherwise than in clerical capacity. In installation maintenance, repair of pumping equipment used for lifting of water from wells, tube wells, ponds, lake, streams, etc., right? Employed otherwise than in clerical capacity, again it should be otherwise than in clerical capacity, the construction, boring, deepening of an opening well, dug well through mechanical contrivances, the mechanical machines. Employed otherwise than in clerical capacity in the construction, working, repair or maintenance of a bore well, dug well, fitter, point, etc. Employed in spraying and dusting of in insecticides or pesticides in agricultural operations or plantation. Employed in working or repair of maintenance or of bulldozers, tractors, power tillers, etc. So as per the available information, the state government of the Andhra Pradesh, Arunachal Pradesh, Assam, Bihar, Haryana, Karnataka, Kerala, Maharashtra, Meghalaya, Odisha, Punjab, Tamil Nadu, and Tripura, and Union Territories, administrations of the Chandigarh, Dadar, Nagar Haveli, and Pondicherry have already made the proposed additions with effect from 15th of September 1995. Right. So the central government has included all the above mentioned employment in Schedule 2 of the Act by amending the schedule. Right. So the matter is not therefore being pursued further with remaining state UTs. Right. So the matter is not therefore being pursued further with the remaining state union territories. Let's move further. So let us see the last amendment of the Act in 1995. So there has been an amendment which was done in the year 1995. Let us have a look at that. The provision of the Workman Compensation Act 1923 were reviewed by the Law Commission of India in 1974 and 1989. Right? The Commission had made a number of recommendations for the amendment of the Act. So based on their recommendation and suggestions received from the ministries, state governments, the Act has been amended for carrying out certain amendments. So the amendments made by the Workman Compensation Amendment Act 1995 provides inter alia for enhancement in the rate of compensation from 40 to 50%, right, and 50 to 60% for the monthly wage in the case of death and permanent total disablement respectively. Right. So that is from 40 to 50% in case of death and from 50 to 60% in case of permanent total disablement. Right. The minimum rate of compensation for the permanent total disablement and death have been fixed at 60,000 rupees and 50,000 rupees respectively, as against the previous rate of 24,000 and 20,000 respectively. The monthly wage ceiling specified in explanation 2 under section 4 clause 1 for working out the maximum amount of compensation has been enhanced from rupees 1,000 to 2,000. The rate of compensation is linked to the age of workman at the time of his disablement or death. Right? The workers getting disabled dying at an early age are therefore entitled to compensation at comparatively higher rate. The provision for payment of rupees 1,000 towards funeral expenses has been made in addition to compensation. The Act has been made applicable to workmen recruited by companies registered and based in India and sent for work abroad. Right? 16 new employments have been added to Schedule 2 in addition to state governments. So 16 new employments have been added. Right? The central government has also been empowered to add hazardous employment in Schedule 2. So even central government has been empowered, right? In this power has been given to central government to add these hazardous employment in Schedule 2, right? The new occupational disease added to Schedule 3. Power to add occupational disease in Schedule 3 conferred also on central government, right? So even central government has got the power. The claimant of compensation may have the claim petition filed, transferred also before the commissioner for the area in which the workman ordinarily resides. Right? Except this all other provision of the Workman Compensation Amendment Act 1995 have been brought into force with effect from 15th of September 1995. Statement showing the names of state which have framed the rules under the Workman Compensation Act 1923 are. So these are the following states which have framed rules under the Workman Compensation Act. These are Pondicherry, Uttar Pradesh, Tamil Nadu, Kerala, Andhra Pradesh, Sikkim, Tripura, Rajasthan, Himachal Pradesh, Goa, Dadar and Nagar Haveli, Daman and Diu, Lakshadweep, Andaman and Nicobar, Maharashtra, right, Karnataka. Okay. Let's move further. So now it talks about here. With this, we have come to the end of this topic, and now let us see the main crux. So, what is the objective? Right? Our objective of the Workman Compensation Act 1923. The Workman Compensation Act 1923 was formed to provide compensation for workers who acquire injuries caused by accidents in the course of employment. It ensures that their rights and values as laborers is maintained. Therefore, employers are obligated to pay compensation to workers who got injuries that led to disablement or even death in the course of employment, right? All right, so with this we have come to the end of this aims and objective of the scope of the Workman Compensation Act 1923. Thank you very much.